What is the fair market value of inherited property? Inheriting property can be a complex process with numerous factors to consider. Before you decide whether to keep, donate, or sell your inherited property, it's important to understand the fair market value of the asset, which is its estimated worth or value on the open market. Is fair market value calculated at the time of death? Yes. For tax and other purposes, the fair market value of inherited property is typically calculated at the time your loved one passes. If you sell inherited property, you may be subject to taxes, capital gains, and other things that you should discuss with a tax professional. What is the cost basis of an inherited house? The cost basis of an inherited house is typically the home's fair market value as of the date that your loved one passed. How do you calculate gains on the sale of inherited property? In general, capital gains are calculated by taking the selling price and subtracting the original cost basis. In other words, if you sell the property for more than its basis, the value as of the date of death, for example, you may have a taxable gain that, again, you should discuss with your tax professional. Does an executor sell property at market value? In general, yes. Executors must sell property at market value, or at least as close to market value as possible. While the specific requirements placed on executors vary among states, executors always have a fiduciary duty that they owe to the estates that they're managing. This means that they must always act in the best interest of the beneficiaries of that estate and deal with them in good faith, including dealing with the properties that they're managing. For instance, under California law, a personal representative can typically sell real and personal property when the sale is necessary to pay debts, the sale is advantageous to the estate and its beneficiaries, the will directs that the property be sold, or if the will gives the executor the authority to sell the property. However, the authority an executor has to sell property can be limited by the will and separately by orders issued by the probate court. And in all cases, those executors must abide by their fiduciary duty to the estate beneficiaries when deciding to sell a property. Typically, in complying with that fiduciary duty, this means that they're going to need to sell the property for at least 90% of the fair market value as determined by a probate referee in a probate estate, for example, in order to avoid a potential claim for surcharge for the difference in that valuation. Can I stop the sale of inherited property? Once someone has inherited property and it's been transferred to them by the executor or administrator through the probate process, they're generally free to do whatever they want with it. However, there might be some situations where you can stop the sale of property during the administration of an estate before anyone legally inherits it and has it transferred to them. This is an issue that commonly arises when multiple siblings, for example, jointly inherit a family home and there is a disagreement as to whether to keep the home or sell it, where perhaps one child wants to keep it and 3 or 4 others want to sell it. Likewise, you may face similar concerns if someone else is designated to inherit a property that you want to keep. Finally, you may have a situation where the executor wants to sell a property, but the beneficiaries want to keep it. Regardless, the best solution to these types of disputes is to try to reach an agreement outside the courtroom. For instance, if the sibling that wants to keep the home might be able to buy out the other siblings outright or offset the cost of the home with other assets that they were going to inherit, that's a really simple way to try to resolve one of these disputes. Even if you want to try to reach an out-of-court settlement, it's essential to discuss your situation with an experienced probate litigation attorney. An experienced probate litigation lawyer is going to be able to advise you on the likelihood of success if it becomes necessary to pursue legal action, which will help you make an informed decision as to how to proceed. An experienced probate litigation attorney also is going to be able to help you negotiate an agreement that stops the sale of the property if that's what's happening. Have questions? At RMO, we protect people like you every day. Schedule a free consultation at rmolawyers.com. Thanks for watching.